It's 12:02. I'm going to just kick off the presentation today, and we'll go from there. Welcome. Today we have a session on newest ESI sanctions order, offers e-discovery 101 course for lawyers. That is the title of the judge's opinion, Judge Johnston. And we're happy to say that Phil Favro, who authored an article about that opinion, is joining us today. And Phil comes to us from Driven, which is an e-discovery company. He has 2 decades experience. He's a witness, he's a special master. He consults on e-discovery issues and has also been invited to speak with the Federal Judicial Center for Training Judges. So with that, we're very happy to have him here today, and welcome to ACIDS Detroit. I do want to kind of give a plug for our upcoming event. We're going to try to do an in-person event on June 24th, and it's our beer and cheese event on the west side of Michigan, and our special guest is going to be Justin. So we're very pleased about that. And so this is kind of going to lay the foundation for that event. And so with that, I'm going to hand it over to Phil. And Phil, welcome.
Thank you very much. Thank you very much. Delighted to be here, and thank you for the kind invitation. I've been looking through the those who've joined and seen who is coming on, and I recognize several names. And I want to invite you to share your screen, or excuse me, not share your screen, but to display your video and to comment throughout this discussion. It's meant to be a discussion. It's not meant to be a soliloquy. And I hope that you feel like you can participate. I am going to ask questions. And for those of you whose names I recognize, I will liberally call on you if nobody else is willing to speak. So please be aware and please be ready. I will give you fair warning, of course. And I just want to make sure we have somebody admitting new people in. Is that right, Cindy, who come at this point to the program?
Yes, I'll take care of that.
Great. Okay, thank you very much. So I'd love to get, and if I can see it even virtually, I'd love to get a show of hands from you, or you can type it into the chat application if you like, but I'd love to get a show of hands on how many of you have actually read the DR Distributors case from front to back, all 256 pages. Anybody done this? Yeah, I see a giant X on somebody, so I guess that's a no for one person. Anybody done this? It is quite the venture. 256 pages. That's off of Pacer, of course. If you prefer to read the Westlaw version, it's only 99 pages. The same amount of words, but for me, the 99 pages just mentally seems more digestible. You might say, why on earth would I want to read a 256-page order? Especially if I'm not going to be paid for doing this. And I can appreciate that. Looking at the chat here really quickly, I'm glad we've got a few comments here coming in. Thank you. We've got Tammy Farmer, partially. That's great. Partially. Sandy, only a few parts of it. That's still some. Megan, skim only. That's all right. Whatever it takes to get a little bit of information. And Karen Sander, you've listened to a couple of podcasts. That's good. And Jay Yelton, yes. So Jay is giving us an unequivocal yes. Good job, Jay. I would say if you do want to go through this, spend 15 minutes a day and do it over 2 weeks to kind of ease some of the pain of doing it. I only say that in jest because this case is really an excellent example of what we need to do and not do in terms of handling discovery as counsel and as legal professionals in general. And we want to talk a little bit about this today and get into some of the issues behind DR Distributors. If you have had a chance, my article is in the ACIDS, it's in the ACIDS flyer or magazine that came around a few weeks ago. And that provides not a 1,000-page, but a 1,000-word synopsis and some of the key issues in the case. And we'll talk about in depth a little bit more of what these issues might be. We'll provide a brief overview for the group today on DR Distributors. What is the case about generally, and why is it an e-discovery 101 course? And we'll talk also about in connection with this, some of the key takeaways that e-discovery is everywhere. We'll talk about active case management, the stop and think mandate from Rule 26G, and other key ESI competency considerations. And again, I note at the bottom Q&A, but that's not at the end. This is, again, designed to be a dialogue. Would very much like to hear from you throughout our discussion. And I'm going to keep the chat application up. So if you do want to communicate a question, you're welcome to come off mute to do so. If you do want to communicate a question and don't want to do it orally, put it in the chat and I will be monitoring the chat. So let's go ahead. So Jay Yelton's read the case. I should just let him present this and handle this, right, Jay? That's exactly what this is about today. I'm kidding, of course. We're not going to put Jay on the spot and ask him to synopsize or summarize, I should say.
Thank you.
You're welcome. We're not going to ask him to summarize DR Distributors, but we will get into some of the key issues. So DR Distributors, to me, is the essence of a dumpster fire. I mean, if you've ever seen a dumpster fire, if you've ever seen a picture like this one, that is what DR Distributors is. A dumpster fire in terms of ESI, understanding ESI, being competent to handle ESI, and so forth. And why do I say that? Because with the DR Distributors case, you have meritorious trademark infringement claims being essentially destroyed by e-discovery and ESI incompetency. And you can see how Judge Johnston characterizes this. Missteps, misdeeds, and misrepresentations by defendants and their former counsel. All of this has contributed to the defendants being placed in a very, very unfortunate position. Now, what is this case? It's a trademark infringement case, and I think it's important to understand this background for a number of points. This is a case that involves two competing brands under the electronic cigarette industry. You have the plaintiff, which markets electronic cigarettes under the name 21st Century Smoke. And you have defendants marketing their e-cigarettes under 21st Century Smoking, each of which has a trademark registered through the Patent and Trademark Office. These are confusingly similar, and customer confusion is the essence of a trademark infringement case. So naturally, you'd have a lawsuit to try and figure out who has the superior mark. The defendants had the senior mark, the plaintiffs the junior mark, and yet the defendants really were the ones that had exceptional amount of trouble. The plaintiffs in this case filed an affirmative defense to the defendant's counterclaim, and that affirmative defense was of unclean hands. The defendants should not be able to enforce their mark, their senior mark, vis-a-vis the plaintiffs because of unclean hands. Keep that in mind as we talk about some of the ESI problems here. So in DR Distributors, you have an initial meeting after the litigation is started between counsel and the client being the CEO for the defendant, 21st Century Smoking. And you think, okay, that's pretty normal. And they review some of the sources of information that could be relevant to the lawsuit. What counsel finds out in this particular case is that the client is using Yahoo email and is also using GoDaddy email and Yahoo chats. These particular communication media have relevant communications. So counsel gives his client an oral litigation hold, and everybody says, okay, well, we'll get the evidence and we're off to the races. But the problem is counsel doesn't know how to get information from GoDaddy or from Yahoo chats or from Yahoo. Counsel thinks that information can be obtained from company servers, and that by going behind the firewall, that data can just be copied off of servers, and that will contain the relevant information. We all know, everybody on this, because you've all got an interest in e-discovery, that is a cataclysmic assumption, cataclysmically wrong. This meeting took place in the 2012 timeframe. These relevant emails from Yahoo did not get produced until 2018. Okay, 15,000 pages worth of emails didn't get produced until 6 years later, and that's 3 years after the close of discovery. The relevant GoDaddy emails, as of the time that this order was issued in January, had still not been produced. The relevant chats from the Yahoo chat application had long since been destroyed, as had several messages from the Yahoo account as well. And so this failure to understand, number one, how messages could be obtained from web-based email, a failure to understand how to be able to get this information, how to instruct e-discovery vendors, which the defendants had, to get this information, and a failure to appreciate the need to be proactive in getting this information instead of reactive has led the defendants and their counsel, as Judge Johnston put it, to be looking down the barrel of a sanctions motion howitzer. And that is quite the description that he put in there, Judge Johnston did, on this particular issue. So as I summarize these issues, I'm wondering, does anybody have any questions about some of the facts that led to this? And as I pose this, go ahead, feel free to unmute yourselves. You can interrupt me or put it in the chat. The only reason why the defendants started producing emails and relevant emails that they could produce was because during summary judgment motion practice, 3 years after the close of discovery, the plaintiffs in their briefing indicated that the defendants had failed to produce many relevant communications relating to the trademark infringement claims. And the failure to produce those messages was evidence of their unclean hands and supported plaintiffs' unclean hand defense, and that defendants should not be able to cancel out the plaintiff's junior trademark. So you can see that these emails were at the essence, at the heart of the claims. And we heard, if you read through the paper, or excuse me, the order, you'll hear over and over again the arguments from defense counsel that ESI was merely a sideshow, that this is a trademark infringement claim, that this isn't about ESI, this is about marks. And as we'll get into in a few minutes, this case is all about ESI, as shown by the claims and the defenses and the counterclaims in this particular matter. The resulting loss of ESI led to a series of sanctions. You can go to the first page of the particular order. It's actually page 2 if you want to be precise. And in page 2, the judge goes through and articulates all the different sanctions that he's going to issue. There are going to be evidence preclusion sanctions. There are going to be monetary sanctions north of 7 figures at least. There are going to be sanctions in the 37B, C, D, and E. And the court only declined to impose monetary sanctions in the 37A because he figured it would lead to, as he put it, a whole bunch of frivolous motion practice. And he wanted to get the case on to trial and not be bogged down with these particular issues. So that's a little bit of the backdrop of this dumpster fire. Questions or comments? Denise, you had showed yourself on the video. Did you have something that you wanted to spotlight for the group's attention, or an issue you wanted to discuss, or a question you wanted to perhaps raise? Okay. Well, very good. We'll wait to call on you for a future time then. So in my article that I wrote about this particular case, I'd indicated that this case is an ESI 101 course. It's a 101 course in what not to do, but Judge Johnston dedicates, say, scores of pages to talking about what counsel should be doing in terms of preservation, collection, identification, search, and so forth, and methods for handling this. And Judge Johnston does so with a number of articles that are dated from the 2012, 13, 14, and preceding years to show that these are steps that counsel should have taken at that time, not just in the 2020 or 2021 timeframe. And as the court indicates, that it expects and the rules require that we as counsel and as legal professionals are going to take these steps and handle them. Now I see we've got a note from Aaron on setting procedures to preserve chat or ephemeral messages that have immediate or short-term destruction can be difficult in the sense of ensuring preservation, et cetera, et cetera. And so he postulates that perhaps no company should use messaging with retention less than their email retention policy. This program is not about information governance. I would disagree with that, Aaron. I think a number of companies have set their retention policies for instant messaging, for example, the workplace collaboration tools, to 30 days or even 0 days, because there isn't a business case for keeping those. But whether that's right in a particular circumstance is up to the business, and whether it's appropriate will be determined by adversaries and, of course, the court. I'd be happy to mention that and talk about that offline. Aaron, I would encourage you to look at the Sedona Conference's recent ephemeral messaging paper. It's commentary on ephemeral messaging. I'm the editor-in-chief for that paper and would be happy to have a discussion with you or anybody else who would like to discuss IG-related issues. So let's keep going. Let's talk in this case now, and we've got a number of reasons why this is an e-discovery 101 course. We'll go into the reasons why that is again, but I want to open it up for questions. Any questions about the background? Jay, you've read the case. Perhaps you have anything that you'd like to share about the case and the background that perhaps I've missed that you think the group would find instructive. Well, if Jay comes off mute and decides he wants to share anything on that front, I welcome his comments. So let's keep going. In terms of how this is an ESI 101 course, Judge Johnston wanted to make the point that we as counsel and we as legal professionals have to take ESI seriously because courts clearly do. That e-discovery is everywhere. Now, you see here on the slide the name Stamatis. That is one of the principal lawyers for the defendants, former counsel at this point. And Jay, I see that you're showing your screen. Do you want to go ahead? You're on mute. Oh, okay. When you get off mute, you just go ahead and interrupt me, and I'll pretend you're the senior partner. You can just jump in and say what you want, and I'll be your associate, and I'll be happy just to jump 5 feet high and listen and follow when you figure that out. So Stamatis was one of the principal lawyers, and he had taken the position repeatedly. And if you have my outline, which I believe was shared with everyone, there are a couple of different quotes, but this is one. The ESI was unimportant in this particular case. And as I've mentioned before, it's critical. The customer communications that were involved were the essence and the key evidence of trademark infringement between the parties. They went to the element of customer confusion and understanding. Says, Phil, you have to allow unmute. I am.
Yeah, you know what? Yeah, thanks, Phil. That was our issue. You know, the host, and I'm not sure, I mean, who our host is really, because it's kind of being run by ACIDS National. So what we're getting it cleared up, but it would not let any of us do the video, despite the fact that you kind of asked us to do that. So it was not to be offensive to you. And then once we got the video back, all of a sudden the host wouldn't allow us to unmute ourselves. But I think we're getting that figured out now. So sorry about that. We didn't mean to leave you hanging there like we're not involved.
It's okay. It's okay. Look, sometimes when I do discussions, there aren't any comments. But Jay, did you have anything that you wanted to share regarding the merits of the opinion and the issues that were considered that perhaps I didn't cover that you felt were important for the group to listen to?
Well, and it may be coming up in your discussion, but yeah, I did have one that I really wanted to kind of follow up with you. Obviously, there's a lot of great things in this opinion, but in the pages like 144, 143, 145-ish, that section, the judge got into custodian interviews and how important custodian interviews are. And one of the things I kind of wanted to get some thoughts as to best practices on that particular piece. You know, we've seen over the last several years really good questionnaires on data preservation, and it came very structured and good software, to be able to send it out, track their responses, things of that nature. And I'm just wondering on custodian interviews, I know that's a bit more difficult because different organizations have different systems and every case is a bit different. But I was just wondering, have you seen software that allows attorneys and practitioners to do better custodian interviews versus leaving them up to the lawyers, or if it's not obviously, hopefully us as lawyers will get more technology sophisticated and be able to do those interviews. But at the end of the day, technology changes all the time, systems changes all the time. And to really believe that a litigator is going to stay on top of it as much as they should, I think is going to be difficult. So I just wondered what your thoughts were. Have you seen good best practices, good software that might be able to help on that front?
Sure. Let me put up something here while we're discussing this. So bear with me just a moment here. See if I can share this now. So these are some of the key considerations in custodian interviews and custodian checklists. Those are, or source checklists, those are some of the things that Judge Johnston hits on repeatedly. And like you say, there's a segment where he discusses it in great detail, but throughout the 256 pages, he emphasizes it repeatedly. So in terms of technology, Relativity does have a very basic interface for custodian interviews that can be used. And I think it's effective for simple cases. But there are technologies that allow for more complex versions. And there is a technology, and I have to say the name escapes me, but there is a technology, and I can share this later, or I have a colleague by the name of Beth Kohler who happens to be on, and if she wants to put the name of the technology in the chat, she can. But in our company, we're using a particular technology right now with custodian interviews that's rather robust, that allows for a lot of follow-up questions. For example, you click yes, you get a question underneath it. You click yes again, you get a question underneath it. So it allows for you, if you want to put it this way, to chase the rabbit. So you've got your outline, if you will, of all the questions you want to be able to put in. And then in addition to having the outline, like if you were taking a deposition, are you an outline guy, or are you a chase the rabbit kind of guy, or are you a both? And I like to think we're both. We have an outline, we want to chase the rabbit as well. And what we've seen with this particular technology is that you can do both. And I'll be happy, Jay, to find out the name of that technology and share it with you, and you can share it with the group if my colleague does not chime in on the technology in the meantime. I apologize, I don't have the name of it down, but we've been very impressed with its capabilities. And as long as we're talking about custodian interviews, the court had made clear, Jay, and the rest of the group, that this initial meeting that counsel had with the client was not a custodian interview. There were no notes taken of the particular discussion about sources. There was no written hold followed up afterwards. There was no discussion or thorough discussion about particular sources that should be investigated. There was no custodian source checklist that was sent beforehand to help prepare the custodian for information that might be forthcoming. And there was very little follow-up. There were none of the indicia or hallmarks of a good custodian interview. And this is something that courts have repeatedly emphasized, not just Judge Johnston, but other courts, that having a good custodian interview is really part of discharging our obligations under Rule 26G, the stop and think mandate. Jay, did you have another comment you wanted to share? You just came off mute.
No, I just still testing. I think you're the host now, and so hopefully people can, other people can chime in. I think we got it resolved. So.
Oh, good. Yeah, feel free to come off mute and feel free to display your screen if you like. I realize there's only 2 of us that have our screens displayed, but I look forward to seeing your cheery faces when you'd like to offer a comment. And thanks for your excellent point, Jay, about custodian interviews. So if we were to go back and look at some of the issues in addition to this, it's going to go back just for a moment. You bear with me just for a second. In terms of e-discovery being everywhere, the court alone has not talked about these particular issues. I wanted to segue to a couple of other cases and really point these to your attention. These are significant points that e-discovery is everywhere. And I don't know if Angela Shapiro was able to join us today. I know that she had some issues she was dealing with back on the office front, but her work in JST Court versus Robert Bosch in terms of being able to obtain a Rule 37E1 sanctions, including an evidence preclusion sanction in that case, that's a good example of the importance of isolating information through a custodian interview. Key emails from a key witness were not preserved. And there was really no evidence that a hold had been issued to this witness, that there was an interview that should have taken place that did take place, and that proper steps were taken to isolate this information. And I raise this case because it's right here in Michigan. It's not in faraway Illinois or any place else. And Angela knows e-discovery backwards and forwards, and I'm happy to tout her good work, even if she's not here right now. But I wanted to point that out. The small case in the lower left-hand corner, one of the things that was one of the key issues that led to sanctions in this case was the inability of counsel in small to conduct proper custodian interviews. The magistrate judge actually appointed a special master. The special master asked counsel in that case for the defendants to conduct custodian interviews, and then he felt that the interviews were so poorly conducted that the master himself, Daniel Gary, actually met with and interviewed the custodians to get the information and found out that any number of categories of information had not been preserved. So Jay, I mean, this goes to your point about the importance of custodian interviews, and whether you're doing it in a large matter with sophisticated software, or you're in a smaller matter, and a lot of you are probably litigating smaller matters, and that's fine. We're not all going to have the $600 million case, for example, the 10, the 9, the 8-figure cases. Sometimes they might be 5 or 6 figures, and your discovery efforts may need to be much more proportional and much less comprehensive. But isolating your key custodians and finding out what they have, that is part of what needs to be done. And these other cases also support this. They support this because you'll find, for example, in Franklin versus Howard Brown, the inability of counsel, general counsel for this healthcare provider to understand what was the retention period for the relevant chats that needed to be kept, chats off of Microsoft Link. Counsel would assume they were 10 years, just like email. This is to Aaron's point, by the way, but in fact, they were much less than that, no more than 2 years, and in many cases less. Everybody knew that the key evidence regarding the wrongful termination claim that Franklin brought, that key evidence was found in the chat application, and yet the evidence wasn't preserved. So we need to conduct custodian interviews. We need to understand information systems. We need to be able to do these things to discharge our obligations under 27G and to be able to get the information we need to marshal the evidence to support our claims or defenses. Any questions or comments about any of these? I want to spotlight a couple of the comments here that we're seeing in the chat. Seen from Tammy Farmer. In private practice, I always ask custodian who else I should talk to, where I should look for ESI, and often they pointed me to key people and places. I think that's right. We're not always going to have a mastery of all the information. In fact, probably most of the time we're not, because we're relying on our client to get us that information. And what I've found, both from a litigation standpoint and even helping clients develop information retention policies, if you're only talking to executives and directors, if you will, senior management and even mid-level management, you're probably not getting the full story. You need to get in and talk to the operations level employees, the rank and file. Maybe management will tell you what they think is happening, but operations level will tell you what is actually happening. So I think that's a great point, Tammy. Thanks for bringing that up. Okay, and Beth Kohler, my colleague, has indicated that it's Alchemer. Alchemer is the particular custodian interview that technology that is much more robust, that gives you, if you will, a decision tree that allows you to chase the rabbit on particular issues. And again, Beth can provide you with information on that either through the chat or through email after the program. We've got a question from Brett. Is it Brett Godush? And Brett, go ahead and unmute yourself and feel free to ask your question if you like.
Sure. Can you hear me all right?
We hear you fine.
I'm just very quickly, I'm not sure the best time to ask this, but I am in-house, and as crazy as it may sound at this day and age, I have never had to deal with e-discovery.
Congratulations.
Just wondering, yeah, but it all, at the same time, it scares me very much that I don't have knowledge. So just wondering where to start for information, education. There's a lot of things, but I'm not sure I have seen necessarily sort of basics at options.
Well, let me just say that you're starting in the right place by being here right now. I think that's an important aspect of this. And I think if I were to answer your question directly, how do you get and possess a basic understanding of ESI? You might try reading my 1,000-word article to get a sense of this. You might try looking at some of the points from this particular case. Take a look, if you will, at some of the points that were made by Judge Johnston. Note the second, and if I could have you mute just for a second, Brett, because we're getting a little bit of an echo. Note some of the stuff that Judge Johnston points out. This is lead counsel in the second bullet. Lead counsel has neither practical experience or understanding of ESI identification, preservation, collection, or production. And he also indicated after this quote that lead counsel had no academic training, meaning he had never really attended a course. Take a look at the court talking about these two particular lawyers, Leif and Lieberman. As part of his sanctions, in this case, Judge Johnston was ordering all of the lawyers, partners, and associates to attend ESI training. And one of the lawyers had actually attended an ESI training course, but had acknowledged in testimony that she hadn't really paid that close of attention. And then this gem of a quote, it just hurts even hearing it. Hopefully, her recollection of this training will be better than her recall of her previous CLE program. So my recommendation, Brett, is to be a part of this program that you're here today where we're discussing these issues. Number one. Number two, take a few notes. And number three, have recollection of these issues. Tammy Farmer points out that the Northern District of California has an ESI checklist, which is a good starting point for speaking to custodians. That's a decent place to go. The Northern District of California's federal court website has great information. I'd say the best place to go, though, is the Sedona Conference. The Sedona Conference is the leading think tank on these particular issues, on ESI and e-discovery. There are elementary resources and there are key resources. I would take a look at the Sedona Principles. That is the flagship document the Sedona Conference has published. Look at the third edition. The document is hundreds of pages. Don't read the entire document. Look at the 14 principles, Brett, and start with that, and then start asking questions. Feel free to email me. I'm happy to just give you some pointers on this. I've been doing this from an e-discovery standpoint for a long time, both with my counsel hat and my consultant hat, as an expert witness and as a special master. Karen Sander indicates, subscribe to ACES and the Sedona Conference. Great advice, Karen. ACES, of course, is a great resource for everything. So those would be some places I would start. You're starting in the right place by coming to this program. Show up at Judge Johnston's event at Grand Rapids in June. I would say that's a great spot. There's no shortage of resources, and Judge Johnston points that out. But I would say the Sedona Conference and ACES are great spots, and I'm happy just to answer questions that you may have from time to time. So getting back to some of these issues in terms of possessing a basic understanding, I would say we don't want to be in this position. I was mortified the first time I read this from Judge Johnston, that he had called out a lawyer. And basically, I mean, it sounded like my father back in high school. Well, Phil, maybe you'll actually remember this lesson the next time. But oh my gosh, and to be name dropped by a federal judge that way, none of us want that. None of us. So that's why we're all here. So what can we do? This is part of 26G. If you don't know what 26G is, let's talk about it. Okay, we're going to skip over the case management for now. We can come back to that. Case management, I feel like, is part of 26G. But if you don't know what 26G is, it's time to learn it. 26G is a provision that's not recent. It was put in 38 years ago, 1983, and is designed to have us as counsel understand what it is that we need to do to have our matters, prepared for discovery. And we do this by not engaging in excessive discovery, not engaging in discovery that is obfuscatory or obstreperous. But we do this, particularly in the digital age, by investigating sources of information, by interviewing our custodians. We do this by making good faith objections. We do this by ensuring that we have taken steps to preserve relevant information and follow-up steps to make sure that that information is safely accounted for and quarantined for purposes of either marshaling the evidence for ourselves or to produce to the other side. On 26G1 is the reasonable inquiry requirement that we have to take basically a diligent search and a reasonable inquiry. 26G3 is the sanctions provision when we fail to do so. Sanctions are mandatory unless there's some sort of substantial justification for you having taken the course that you've done. Judge Elizabeth Stafford, I know all of you know her because she's based right there in Detroit. Judge Stafford issued the Ephius opinion back in, I think, the summer of 2020, discussing how defense counsel in a particular case violated Rule 26G3 by engaging in obstreperous discovery and serving overly broad discovery requests. But we see more and more judges threatening to sanction or sanctioning parties and their counsel when they don't stop and think. And part of stopping and thinking is understanding ESI. Failure to quarantine and isolate ESI and preserve it and then produce it and then signing incomplete or inaccurate discovery responses can get us sanctioned as counsel and client under 26G. So we've had a number of helpful chat points made here, or helpful points made in the chat. I want to thank everyone for that. And I want to pause here for station identification, if you will, to see if we have any other questions or comments that you want to raise at this point regarding the stop and think mandate or possessing a basic understanding of ESI. Yeah, great comments here, Sandy. Make sure your outside counsel has ESI competence. That's a key issue, if anything, we find from the DR Distributors case. And the ABA Discovery Conference that's going to take place next week is going to be excellent. It's designed for in-house counsel, but anybody can attend that event and get a lot out of it. I've spoken at that event in the past, and I highly recommend it. Let's talk about client information and communication systems. How many of you really take an interest in what the client's doing with its information systems. I want to put a few people on the spot here. I want to ask Christine McKinney. I know you're here. I've seen your name. I know you're not outside counsel, but if you don't mind me calling on you just for a second. Christine, has it been your experience being in-house? Have you seen a lot of, what's your experience in terms of outside counsel? How diligent are they in terms of asking you about your information and your communication systems? Do you see them taking an interest in this, or do you have to prompt them to take an interest in this?
Generally, can you hear me? Did I get off?
We can hear you great, Christine.
Okay. Generally, they do ask. I would say the only time that it's more me guiding that conversation is, and I don't want to say if they're smaller that they don't necessarily know ESI, but I might get some smaller firms as we have litigation throughout the entire country. Bigger firms that are more adept, they definitely are going down and asking this. So I still do get some that are maybe not as adept and had as much experience, but I would say generally overall, they are making the right inquiries.
That's great, Christine. Thank you very much. And thank you for letting me put you on the spot there. Christine is extremely knowledgeable, very knowledgeable on e-discovery issues. And if she were litigating as outside counsel, I have no doubt that she would be asking all the right questions, but she does a tremendous job for her organization. Thank you, Christine. Asking about information systems is essential. How will we know what information systems the client has unless we ask about them? How do we know about communication systems if we don't ask about them? At Driven, I have been holding corporate roundtables and getting a sense of what types of workplace collaboration tools organizations are using. In-house counsel has responded with any number of different systems. It's excellent that in-house counsel know the systems that are being used, but do outside counsel know if you are using Teams, if you're in-house, if you're using Slack, if you have a policy that forbids the use of iMessage or ephemeral messaging apps, but it's never enforced, and so it's going on. Will senior management tell you nobody uses ephemeral messaging apps? I've had clients tell me, for example, nobody uses personal cloud applications in this organization. Nobody uses Google Drive. Nobody uses Dropbox. And I've tried to be as gentle in my response as possible. I remember to one CEO and said, well, I appreciate that you think that's what's going on, but in fact, I'm willing to guarantee that everybody in your company is using these applications. And he repeatedly tried to disabuse me of that notion. But when I conducted the custodian interviews, my guess was right. Dropbox, Google Drive, and so forth were being used. They weren't company sanctioned tools, but they were information systems, if you will, non-sanctioned information systems with highly relevant information to the dispute. These are questions you need to ask. Going back to the custodian checklist, do you have a custodian source checklist where you've gone through different sources? They could be messaging apps, they could be enterprise cloud apps, they could be personal cloud apps, and so forth. Are you looking at these particular apps? Are you asking questions about those? So you can't understand and get your arms around the universe of relevant information unless you know what the client information and communication systems are. And you most likely need to have a custodian checklist, or you need to have custodian interviews or an interview with IT, as well as in-house counsel to get that information. Any questions or comments about this? If you go ahead, Jay.
Yeah, I was just going to mention, 26G, as you said, I mean, that is so key to this opinion. And one of the interesting components is on page 87 and 88. And I like the court's statement, Rule 26G's reasonable inquiry requirement is not met merely by eyeballing the volume of documents produced. And I think there's been historically, that's probably been very common. You know, how could we have failed to comply with discovery? We produced 100,000 pages or what, you know what I mean? And he clearly says that is not enough. And as us as lawyers, as we sign a 26G or certification when we've complied with discovery, clearly the court's requiring more of us. Now, obviously, lead litigator can't be reading page by page on every single page. That's not possible.
Right.
But I kind of wanted to, you know, throw out to you a little bit about what are some of the ways that an attorney can comply with that 26G requirement and really kind of, again, probably have to leverage technology in many ways. You know what I mean? Because the other thing the court clearly says is you can't rely on just your client's statements to you. You know what I mean? That would be nice. Oh, they said they got it. That's good. Court says that's not enough. And the court says looking at the total volume is not enough. So there has to be more that we have to do as attorneys. And I just wondered what some of your thoughts or best practices are on that point.
Yeah, I appreciate you bringing it up. You brought up several points here. So let me try and respond to these. I'm not going to object as being compound because there's so many great points there, Jay, to bring up and raise. So first of all, the point about eyeballing. A couple points on that. Well, we've eyeballed the production. There's a sizable amount of documents. In fact, we've produced more than the other side. We must have met 26G. And production volumes, I mean, that is a non sequitur. It could be 10,000 documents. It could satisfy it. It could be 1 million and it doesn't satisfy it. I mean, I had a production order one time where we had to go to 5 different continents to be able to pull electronic and paper documents. They're well over 20 million pages. Well, if we had produced 5 million pages of documents, we could have pointed at the production volume and we would have still been far incomplete in terms of a fulsome production that we had to make. And so I think one of the points I wanted to make is don't be duped as counsel or as legal professionals about production volumes. That is truly a non sequitur. Now, in terms of relying on the client's representations under 26G, we have an independent obligation to investigate the issues. And the HM Electronics case that I mentioned, or that's much earlier in the slide deck where I had the 4 different cases, HM Electronics is the predecessor to DR Distributors. And in that case, a lawyer from LeClaire Ryan and the firm itself were sanctioned under 26G for inappropriately relying on the client's representations. In that case, the client, the CEO, had told LeClaire Ryan, hey, we keep every document in the company. That's our policy. We keep everything. The law firm said, great, well, that's good to know, and then just went on. Now, the court said, you know, basically like Judge Sirica in the Watergate case when he asked Hugh Sloan whether he had a college education or not, given the answers that he was accepting from Nixon's henchmen in the committee to re-elect the president. In like manner, I think Judge Denbin in this particular case wanted to ask counsel whether he had ever thought about going in a little deeper. I mean, couldn't you have asked the client, well, that's interesting that you keep every document. Nobody deletes any messages. Nobody deletes any documents out of databases. Nobody modifies them. Is that by policy? Great. Can I see the policy? Is that by practice? I'd like to see the practice. It can be done without sounding like a jerk because we have to have a good bedside manner in our role as legal professionals. Okay, we can't put off the client, but we have enough training to ask these questions and ask them in a polite way. You keep every document. Okay, could I see the policy? Can I interview IT about how the policy works? And if the client's not willing to give you access to the information you need to corroborate that particular representation, then maybe you need to let the client know that you're not going to be able to do your job for the client unless you get this information. I think we can ask good questions, Jay, to your point. We can be able to get in and we can leverage technology, but sometimes it's a matter of leveraging our understanding as professionals to get to the issues. We need to do that under 26G. That's part of our duty of reasonable inquiry, I think. But yes, custodian checklists, sending those out. I think I keep going back to that point, but it's a great starting point. Sharing some of the lessons that may have been learned from other cases. If we don't disclose this information, we're going to be sanctioned. Are you sure that we've given everything over? Of course, it's a privileged conversation, but emphasizing those points would be super important to me. Last point about eyeballing, Jay. Some people like to eyeball a production. Well, I eyeballed the production, so I know that it's relevant and proportional. I know it meets Rule 26G. That's not the way to meet 26G. If you want to eyeball a production to be able to do that, put your eyeballs on a sample that's generated by your electronic service provider. Whoever that provider may be, have your provider generate a statistical sample of your production set and your discard pile, your non-production set. In ESI jargon, it's referred to as the null set. Look at both of them. The production set should be what you think it purports to be after you review the sample. And the discard pile should be filled with irrelevant information. But if it's filled with relevant information, you're going to need to go back and start looking at how you blew it. Sampling is a great way of putting your eyeballs on these documents to make sure you satisfy 26G. Responses to that, Jay. And Cindy, you're off mute. Go ahead.
Sure. Having worked on both sides of the fence, both in-house at legal departments and then with law firms, I can confidently tell everybody that there's a big kind of assumption by law firms that their clients understand their data and know where it is. And likewise, you know, the clients believe the law firm is going to walk them through everything they need to know. And oftentimes those two things work against each other, where law firms are afraid to push, you know, to make sure they get all the good data. And then the clients also, you know, they kind of, many in-house counsel, you know, they don't necessarily do a lot of litigation or discovery, and they really don't know what they should know or what, you know, what they need to do. And so I would just, you know, in my experience, I always tell people not to assume anything and just kind of start with a basic checklist and just follow the process every time. And if, you know, if everybody's informed, then great, but there's a good opportunity to kind of start at the same basis every time and just have good process.
Excellent, Cindy. Thank you for sharing that. Thank you. We've got a couple more questions or points in the chat. We've got one from Ethan Ackerman. Ethan, greetings back to you. Ethan's a very, very accomplished e-discovery attorney with Morgan Lewis. Ethan indicates that one point in Judge Johnston's opinion, he goes into the lost information cannot be restored or replaced. Do I want to share on that? I think the point I would share on that, Ethan, is that there was a lot of unique evidence. The idea with 37E and sanctions issued under Rule 37E is that the information really, to be able to get sanctions, you have to show it's unique and that there's no other sources of the information. There was an opinion a couple of years ago involving tech titans, Oracle America and HP, out in San Francisco in federal district court there, where the court had found that, look, we know the CEO of Oracle America, his name is Mark Hurd, and he used to be the CEO of HP. We know he's destroyed 550 documents, and they are key documents, and it doesn't look like there's any good reason that he's destroyed them. It looks fishy. But the judge said, it's Judge Elizabeth Laporte, by the way, who's since retired, but she had said, I'm not going to sanction Oracle America because all of the documents in question can be produced from other sources within Oracle America. They weren't unique. So yes, it looks a little crummy that they've spoliated the information, but there's other information to replace it. It's kind of the no harm, no foul rule, like the Detroit Pistons, the bad boys from the late 1980s would have said. There's no harm here. I don't see too much blood on the floor. There couldn't have been a foul. At least I think that's probably what Bill Laimbeer used to say, and all of his colleagues that all of you watched with great interest back in the day. but that is the requirement here. If there's no harm, then there's no foul. But if it's unique, and a lot of the evidence here in DR Distributors was unique and it couldn't be replaced, then that information, when it can't be replaced, that tends to suggest that sanctions should be issued. So thanks, Ethan, for that. We've really got just a couple of minutes left. I'm happy to keep entertaining questions. You can see, and we're happy, Jay and Cindy, I'm happy to show the, I'm happy to share the slide deck. In fact, Cindy, you're welcome to share the deck that I gave to you, a PDF of it, if that's okay, please, rather than the PowerPoint with all of the attendees. And I'm happy to answer questions by email afterwards. I think, go to the end of the slides, I think I have my contact information in here. I do. So you're welcome to email me or call me on that number. I'm happy to do that. But in just our last few moments, if there's any other questions, I think a key issue here that we haven't talked about, and I know Jay asked me to do this, this should be obvious, but for some lawyers it may not be. Use a service provider and use an e-discovery platform. Not everybody conducts e-discovery on a platform. Now look, you might say, Phil, I've got a $50,000 matter. I'm just going to sort through it myself. I'm going to do that. I would say that that may be okay, but when you're doing it yourself without a platform, Jay, you can elaborate on this because I know you wanted me to emphasize this. Doing it yourself without a platform usually leads to a lot of errors. So Jay, go ahead if you want to pile on this particular point.
Yeah, I just, my experiences, and obviously I'm not selling platforms or anything, but
Right.
once you get to a certain number of documents and data to comply with 26G on reasonable inquiry, I mean, there's so many different reasons why I think a database and being able to, I loved your example a couple minutes ago, sampling, right? I mean,
Right.
So this database is going to allow you to sample. It's going to allow you to double check your privilege and confidentiality and relevance. And it just gives an attorney some ability to comply with 26G. And so, so no, that was why I wanted to, for you to mention that, because, and you know, people disagree as to what's the quantity of data that one needs, whether it's 50,000, 100,000, pages or whatever. But I think the cost, in my experience of the ability to do that has come down so much that, it's almost essential for, and, for the great majority of cases going forward, I believe.
I agree. And we're still seeing lawyers out there printing documents for review and producing them, even tens of thousands of emails, printing these out and reviewing. I mean, that is the very definition of insanity, right? Doing the same old thing and expecting different results. A couple other points really quickly, because we are at the top of the hour. Consider whether you want to push or pull information. Sean Cheadle from Lockheed, he's the general counsel for Lockheed Space Systems. And he and I discussed this issue in an article that's referenced in the outline that we shared with you about whether you push or pull information from custodians, whether you're outside or in-house. And just keep in mind, you can allow custodians to push information to you. You don't have to micromanage, but you do have to be involved in the collection process at some level. And if you have incompetent witnesses who may destroy information, or if you have interested witnesses, like the CEO of the defendant, in this case, he was a completely interested witness. He could not be trusted, if you will, to manage his own collections. Or if you are dealing with a witness who is the alleged harasser in a wrongful term case, that custodian cannot manage his or her own production, or collection and preservation. You've got to get in there and deal with it. So I did want to mention that. Anyway, again, we're past the top of the hour. I'm happy to stick around for a few more minutes and answer any questions, but I think it's appropriate for me to wrap up at this point. I want to turn it back over to Jay and Cindy.
Thank you, Phil. We really appreciate your time. I posted in the chat, but also want to make sure that everyone knows that this recording will be made available through ACIDS National as they hosted it for us. And we will include the presentation as well as your outline. So if anybody has any other questions, you can always reach out to me. I can get information to and from Phil. You can reach out to him directly. And also, if you do want to ask questions of Judge Johnston in our June 24th event, you can submit those to me or any other of the board members. And although they can't be case specific, he's welcomed any of your questions and your, the issues that you would like to discuss. And we'll be following up with a save the date announcement on that event shortly.
Terrific, terrific. I would say pose your questions. Judge Johnson is very engaging and he is very, very relaxed and casual. He will very much enjoy speaking with you about these items. He is, like you might suggest, just like all of us, he puts on his robes one sleeve at a time, and he doesn't take himself overly seriously in that way. So he's very approachable, but he will approach these issues with great seriousness and give you good instruction. So with that, I think we're going to finish this up. And thanks everybody for joining, and our best wishes to all of you.
Thank you. Thanks, Phil.